It may have just gotten easier for authorities to obtain your cell phone records. Yesterday, the Fifth U.S. Circuit Court of Appeals overturned an order by a federal judge in Texas who had said that cell phone data is constitutionally protected from intrusion and can only be acquired with a stringent search warrant. This scares me, Bianca. I don't know. What does this mean for privacy rights?
So basically what they're saying here is that all of this, the data that your cell phone collects about where you are and where you're going, that belongs to the service providers, right? That's not your data. That's being collected by, let's say, AT&T or Verizon, and so you don't have a reasonable expectation of privacy.
But what can they do with that data? Because if the argument is it's not mine, it's sort of a meta level.
So the point is that there's someone running an investigation. They don't need a search warrant. They just need a court order. So it's a little less of a burden to actually get that information.
Because the search warrant will require a higher level of probable cause.
Right. And so the point is just that it has to do with I think it raises the interesting question of, whose data is who does it belong to, and also what can we do about this, right? I mean, is this a matter of, does this become a competitive advantage somehow where maybe one day we have cell phone providers that have different treatments of our data, and so you might be safe from ever having, data potentially handed over for a court order. But I think, they talk about this potentially going to the Supreme Court as an issue.
I can't imagine that this won't go to the Supreme Court. The stakes seem so high, and so many people are deeply invested in what's going to happen.